Yesterday, the Supreme Court dismissed a case over former President Donald Trump's efforts to block critics from his personal Twitter account. The court ruled the point is moot. That since the former president is no longer in office and has been kicked off of Twitter. But Justice Clarence Thomas wrote a separate opinion saying the case raises much bigger questions about the power of social media companies. Joining us now is Rachel Beauvard, Senior Director of Policy at the Conservative Partnership Institute. Rachel, welcome back. Good to see you. Let's talk a little more about Justice Thomas's opinion. What stood out the most to you?
Well, I think his very clear grasp of the world as it is right now, which is, our speech, our access, our information, all being threatened by this very concentrated power in these big tech companies. And I think what was really striking about the concurrence that he wrote was his humility in the face of that, saying, look, we are dealing with a new technology that has unprecedented control over how we live in a free society as a free people. And we need to think carefully about this question. He laid out some justifications for how he thinks, this could be addressed via public policy implemented by the legislature, that being common carrier regulations. But I think he was very humble in the face of this new threat and really urging the legislature to act, but also I think inviting some challenge legally, where the Supreme Court could actually intervene and rule in cases where he thinks the law has been misinterpreted or misapplied by the lower courts as it relates to big tech.
One of the things he mentioned was Section 230, that major protection for internet companies. Why is this law controversial, particularly now?
So Section 230, actually, Justice Thomas has opined on this before in previous opinions, and it's big tech's government subsidy. It's a law from 1996 that, in Justice Thomas's telling, has been sort of judicially distorted and bloated away from its original intent. And in doing so, it has made these big tech companies some of the most privileged First Amendment actors in our society. They are shielded from all kinds of different liabilities in their ability to moderate content that allows users no recourse. If you are blocked or if you are censored on these social media platforms, they are immune from any kind of liability with that regard. And Justice Thomas's argument is, look, this has been so stretched. What was intended to be a very porous, a very narrowly tailored immunity, simply to just clean up the internet, to incentivize the companies to remove, lewd content that nobody wants to see, has been so stretched that it's given these companies massive amounts of immunity, protecting them from, sex trafficking, flourishing on their site they're not responsible for. So I think, he really wants to bring it back to its original intent. Now, that is very controversial because the big tech companies make a lot of money off this provision. So they, of course, want it to remain as it is.
Yeah, and as we know, lawmakers on Capitol Hill have had the heads of social media giants for testimony on Capitol Hill several times in recent years. What, if anything, has come from those hearings?
Well, not much in the way of legislating. You see, what is now almost a routine occurrence of these big tech CEOs being brought before Congress. You see legislators, ream them out or sort of beat their chests about how terrible social media is, and then nothing changes. And you're starting to see these big tech CEOs actually, mock these hearings. Jack Dorsey, the CEO of Twitter, during the last hearing in front of the House Energy and Commerce Committee, tweeted out something in the middle of the hearing, seeming to mock how the questions were being presented to him as a yes or a no. So I think the time, and I think many Americans might agree, that the time for hearings has ended and the time for action is now. The hearings are not going to cut it anymore. I think people really want to see the legislators do something.
And Rachel, before we wrap up, what would you like to see happen with big tech companies? And also, what type of impact do you think that Justice Thomas's opinion will have?
Well, there's a number of areas I think that could be addressed regarding big tech. The first is antitrust enforcement. You're already seeing this work its way through. The Department of Justice has filed a lawsuit against Google under our antitrust laws. They're joined by almost 50 state attorneys general. I think that will have a big impact because, again, a lot of the impact of these companies comes from their sheer scale. And the reason we don't see many competitors actually rise up to the level of true market competition is because, as the government alleges, these companies are monopolies. So I think robust antitrust enforcement to protect the free market in tech is a good first step. Section 230 reform, obviously, I think very critical to this effort. And then finally, as Justice Thomas laid out, potentially Congress can consider some common carrier regulation. And that's the same regulation that applies to telegraph companies, railroads, AT&T, Verizon, respecting that these are private companies, but putting on them responsibilities not to discriminate against certain speech or against certain content. This is not a new regulation invented for tech. This all goes all the way back to its roots in the English common law centuries ago, and Justice Thomas laid that out. Now, I do think because of Justice Thomas's concurrence, you will see some cases, hopefully being challenged and brought to the Supreme Court so that the justices can weigh in here, specifically with regard to Section 230. Has it been misinterpreted? Should it be clarified by the high court? I do think you're going to start to see some challenges in regard to that because Justice Thomas has said almost effectively, bring them to me. I'm ready to hear them.
All right, we're going to leave it right there. Thank you so much, Rachel. Rachel Bovard, Senior Director of Policy at the Conservative Partnership Institute. Thanks again.
Thank you.